Proceeding before trial. Arrest. To establish an arrest, probable cause is needed by police officers. They must be able to point the objective circumstance leading them to believe that a suspect committed a crime. With an arrest, a warrant is needed, issued by a judge, or without a warrant if there was probable cause. After the arrest, booking is done. Booking is the formal process of making a police record of the arrest. At this time, the accused is asked to provide information including name, address, date of birth, place of employment, and other details. Initial appearance. The judge explains to the defendant their rights. It explains the exact nature of the charges against the defendant, states that the defendant has a right to an appointed attorney, and if one cannot be afforded, then one will be provided to them. Bail hearing. The judge or justice of the peace then decides to either release the accused or bail them or keep them in jail while they wait for their trial or some other results. Preliminary hearing. A trial before the trial, where the judge decides whether or not there is enough evidence to force the defendant to stand trial. The hearing still uses the probable cause legal standards, but uses a more logical, such as to whether the evidence that is going to be used to make a court case Arrangement and pleas. Arrangement is a court processing at which a criminal defendant is formally cut. We can do that slide again. Arraignment and pleas. Arraignment is a court processing at which a criminal defendant is formally accused of the charges against the individual and is asked to enter a plea into the charges. A plea is the answer to a claim made by someone in a criminal case under common law. Under common law, a plea of guilt of the defendant waives trial of the charged offenses, and the defendant might be sentenced immediately. Trial. In order for a defendant to be found guilty, the jury should find him or her guilty beyond a reasonable doubt.